Good morning, Mr. Owens. You can step up to, are you going first? You're going first. Mr. Owens, I know that you've been sitting in the back and you may have been watching, but you may also be nervous. So let me just remind you of the rules. You will have 10 minutes. If you can watch the clock, when the yellow light begins to flip, it means you've got 1 minute left. And when the red light begins, please stop talking unless you are answering a question of the justice. Okay?
Yes.
Good morning, Mr. Owens.
May it please the court, my name is Roy Owens, and I'm pro se. Two questions. I'd simply like to start with question one. Is the Superior Court error in not holding the City of Boston and the Boston Police Department responsible for their agreement to substitutions of parties in exchange for dropping complaint against Officer Ward? Now, the city will argue that it's presentment. My answer to that is that's a mute argument, because in the middle of the case, the city requested to become a party, and they're arguing that the city wasn't presented within the 2-year period, so therefore it's presentment, and that's for there should be dismissed from the case. My argument is the city came in the middle of the case and requested to be, in the City of Boston and the Boston Police Department requested in the middle of the case to become defendants. And therefore, it is mooted to argue the defendant position that she has, will be arguing this position. This is her position before the court. And the whole position is on presentment. And I'm saying it's mooted based upon they volunteered to become a substitute in order to drop Officer Ward from the case. Now, as to that issue, on 12/2/03, and we find that as a part of the appendix in Exhibit A, on 12/2/03, Officer Justice Joseph Walker III allowed the city to become a part of the case on that date. That's in the middle of the case, not at the beginning, not before. So I want to make that clear, and it's not presentment. Presentment should not be allowed to be argued here. It's not a part of it. That was argued in the Superior Court, and Judge Bradley dismissed the original on presentment. Then it went to the appeals court, and the appeals court reversed and said, no, we believe they reversed. Well, actually, the argument wasn't argued, because I'm assuming that it's common sense that in the middle of the case, if they agreed to be a part of the case, it can't be presentment. So I didn't argue that. I take that back. What they did is it's another part of the case. I'm going to get to this real quick. Let me finish on presentment. It wasn't presentment. It was substitution of case. And there's a case that's called New Parties May Be Brought In to Amend Even After Statutes Have Run. Wadsworth versus Boston Gas, 352 Mass 86, 223 Northeast 2D 807, 1967. And so that's the case that would regard and allow the City of Boston and the Boston Police Department to become a part of it. And so Judge Walker allowed that. Now,
wasn't the City of Boston, didn't the appeals court affirm the dismissal of the
on
city
presentment? And I'm saying there's an error. That was an error, because it never was presentment. The City of Boston argued presentment. They're arguing presentment here before you so that you will not pay attention to the fact that it's substitution. It's not presentment, it's substitution of defendant. And so I'm saying if you accept the same argument that Judge Bradley did, then you will default dismiss the case on presentment. If you follow the same one that the appeals court, then you will do it on presentment. And I'm saying it never was presentment. They didn't even look at my argument. And I'm saying if you do the same thing here, they don't even bring up substitution in here. They write this whole brief. They do not mention it. They don't mention the case that I just mentioned. Yet I put it in mine. But they left it out so that, and then they went back to Judge Bradley. They went back to the appeals court and said, all this is presentment, see? And so that your mind is never looking at substitution. And I'm saying today, as Barack Obama saying, look at what courts got to look at the overall picture, not just just look at what the state is presenting, what the city, but look at, give the citizen a fair break and look at them. That's all I'm asking on that. Now, to move to the second part of the issue, and that is, also, let me do this and then I'll move to the second part. Outside of that, also, we have on Exhibit B1, it says in here that they are dropping Officer Ward from the case and adding the city plus the city of Boston, Boston Police Department, and Officer Figueroa, which was a part of that the city submitted that should have been, his name should have been on there at the beginning. And I had requested that several times. Until that point, they had refused to give the name. Also, in addition to that, we have B2, which is also go along that was submitted from the defendant that about the substitution of that. Now, moving to the second part of the case, which has to do with the default. And I had requested that the city of Boston be defaulted. I served them, had them served, by constable served, on April. They did not answer, and it says you must answer within 20 days. They did not answer the default, so in June, I filed for a default. And the court, the correct magistrate refused to give me a default. And for 6 months, well, actually went 10 months. The city of Boston never responded within 10 months. I gave them 2 services. It was served twice. They defaulted, they didn't answer. But they took time during that 9 months to call to court and talk to the court. They knew they and they still didn't answer. And so what happened is I filed a paper in the court to force them to come to court or force the court to give me a default judgment. Even though I had already notified the defendants that they would twice, in a third letter when I sent to them saying that you are defaulted, and the courts would not. One of the judges that I went before, she said she removed herself. You'll find that as a part of the Exhibit A in the appendix, that she excused herself from hearing it. She said, I might be prejudiced, so I don't want to hear it. Another judge said to me, well, send them another letter. And that was this is like now, December. Send them another letter, tell them to come back in, A9. So I sent a 9 to them, and then I still wouldn't do nothing. So I went before, I requested from the judge, Chief Judge Barbara, that forced them to at least make the judge, have some judge to hear the case. They would not default them, and they would not hear my case. So I had to go before Chief Justice Raw. Chief Justice Raw had Judge Bentley to hear the case at 8 o'clock in the morning because none of the other justices wouldn't hear it. They would think of some reason not to do it. And so he heard it, and he just, after the city came in, he didn't hear my argument. He just heard the city argument, asked for default. They said they had not, that I had not addressed them, they had not received service from me, although I had served them twice. And now what happened?
Mr. Owen?
Yes.
Can I ask you a question?
Yes.
Judge Spurlock,
Yes. I'm getting to that.
he provided you with an opportunity to serve by sending it to the city's council.
A fifth time.
Right. So,
To the same exact people that I served from when they defaulted. In 2002, it was served on the city of Boston, the Boston Police Department, and on their job where they work. Then the city
okay,
said,
let me just.
Yes.
So, essentially, as I understand it, you served them, but
Yes.
for some reason they said they
they
had.
said it
been
wasn't at their home.
Fine.
It wasn't last
So
boarding
the-
address.
So there was a back and forth and very frustrating, and eventually Judge Spurlock said, I'm going to say that it's okay for this defendant to serve these individuals not by at their homes, but by giving the city, right?
Well, prior to that, the city had already agreed to receive services, and they received from the defendants. Prior, Judge Cressley said, I want you to get from the defendant, and told them they would send me a letter. Before I sent the April service, complaint and service, I received from them in writing that from the that they had received from the defendant that they would represent them. And they
Okay.
sent that letter to me before, and the judge told me to get that before I sent that to him, so I did. Now, so therefore, I only need to send it to the lawyer who's representing them.
Now, after that, was there another hearing after that in the Superior Court where your complaint was dismissed?
My complaint was dismissed it was dismissed in
Not the first go-around.
the second.
After Judge Spurlock said,
After Judge Spurlock, because the motion for Judge Spurlock was that he could either default the defendants or he could have them to reserve again.
right, and he said reserve them.
He said reserve. But my argument is that they defaulted, and there was no reason to reserve them again because all 4 of the times, they defaulted 4 times. All 4 of the time it was served on the City of Boston in the clerk's office. In the clerk's office, they came and testified before Judge, what's the name?
Spurlock?
Judge Spurlock, all of the time they received it, and they gave me a copy that they received all of those. And that was their job, the clerk's office, to receive summons and complaint. Before Judge Spurlock, the defendant, the attorney for the City of Boston admit that, yes, even though they had told in writing, here, and before Judge Bradley and the rest of them, that, yes, no, we didn't receive it. But before Judge Spurlock, they said, oh, yeah, we must have received it. And here's a copy. And the appeals court also looked at the copy and said, yeah, they received it because here's a copy from the clerk's office. But they was telling to Judge Bradley that they didn't get it, even though it was I have it in writing and it's before you.
Can you tell me what happened after that? After Judge Spurlock?
After Judge Spurlock, he had me to reserve it to the same clerk
Right.
office.
And then what happened?
Was there a trial or something with the
Was there a
defendants?
hearing after that? Did you go before a judge after that?
No, I went.
Was there a
this is
hearing where the
before-
the
case is
the
still
office?
in the case now is before, it's in the Superior Court, but it's not, but it's in the Superior Court right now. The case is, and the case came up before another judge the other week.
I can ask the city's lawyer because she probably knows what the city did more than that you know.
Well, what happened is before, I can answer that. Before the city now saying that the judge that came up before him, that they wanted to dismiss it on basically the same thing, another judge, but wanted to dismiss it basically on the same rule, and that they're arguing that the defendants can't be tried, and their only option they're using is 258, and they're not looking at all of the things that happen. And so it's going to probably come up again.
Okay. Thank you, Mr. Owens. Good morning, Ms. Ferrer.
Good morning. May it please the court, Nicole Murati Ferrer for the defendants. Your Honor, just to start, I want to inform the court that as of September 12th, the case in the Superior Court terminated as the judge found in favor of the defendants on their
Well,
motion
that's what
for
I was
judgment on the
asking Mr.
pleadings.
Owens about. So it was on the basis that it was dismissed.
Yes, it was dismissed.
On what basis?
Well, the only remaining counts were against the city officers.
Yes, and what was the basis?
What
for
was the
dismissal?
basis?
The basis is that the plaintiff appellant is bringing claims against them under Chapter 258 in their official capacities, which is tantamount to bringing the complaint against the City of Boston and the Boston Police Department once again.
And did Mr. Owens participate in that hearing?
Yes, he did.
And that was before whom?
That was before Judge, one moment, Gaziano.
Baziano. And did Mr. Owens take an appeal from that judgment?
Yes, on September 22nd, Mr. Owens filed his notice of appeal.
So Mr. Owens will be able to appeal that judgment.
And can raise in that judgment the question of whether the default judgment should have entered against these officers, correct?
Absolutely.
so that what Mr. Owens can raise, and that'll go first to the appeals court, I assume,
Yes.
that his position that Judge Spurlock should have entered a default judgment, and that Judge Graziano should not have dismissed the claims.
Yes.
So they're all in that one appeal.
Yes, I believe that at this point, this review of this interlocutory matter is now moot.
Ms. Ferrer, why did you, I guess I'm a little confused why you argued in this brief about why the city isn't liable, because as I understand it, the appeals court affirmed on that judgment in 2006 there was no application for further appellate review. I just don't know why that issue is open at all.
And Your Honor, respectfully, I would say that it is not. The only reason we brought it up in our brief was because Mr. Owens had it in his brief, and to be honest, there have been so many attorneys on our side that the back and forth and the multiple dockets were sort of confusing, so we figured to cover all our bases.
But do I have the chronology right, that there was a judgment, I mean, a decision in the appeals court in 2006 and on the city's liability, not the individual officers, but the city, and that nothing further has happened with respect to the city?
You do, Your Honor. That's absolutely correct.
Thank you.
Yes, I rest on my briefs. Thank you.
Thank you very much.